Welcome back to the deep dive. Today we are wading into some pretty murky waters. We're looking at regulatory oversight.
Specifically the Australian Securities and Investments Commission, or ASIC.
Right. And we have this stack of source material today that just lays out a massive, almost unbelievable contradiction.
It really is a study in contrast. On one hand, you have ASIC's own perception of its performance, which is glowing.
And on the other, just devastating external criticism, a lot of it coming straight from Parliament and from the victims of financial crime.
So our mission today is to try and reconcile those two conflicting realities. How can a regulator claim it's getting widespread positive feedback when a billion-dollar financial scandal seems to show a massive systemic breakdown?
Exactly. And the tension is there from the very first document. We've got ASIC's General Counsel, Mr. Chris Savundra, on the record.
This was before the Economics References Committee.
Yeah, and he states that ASIC had received largely positive feedback from past parliamentary inquiries. He even lists them off. The 2011 Trio Capital Inquiry, one in 2013, the Sterling Income Trust Inquiry from 2021.
And here's the kicker. His main argument for this positive view was that none of those inquiries, he says, actually required ASIC to publicly disclose its internal case files.
That framing is just so telling, isn't it?
It is. It's like they're treating the absence of a court order as proof of a good report card. It's about compliance, not, effectiveness. But when you start peeling back the layers on the sources, especially around the Trio Capital case, that whole claim of largely positive feedback, it just seems unusual.
Okay, let's unpack this, because for anyone listening, you need to get the scale of the case they're talking about here.
It was huge.
Trio Capital wasn't some small-time scam. This was a massive international fraud scheme. The Supreme Court of New South Wales actually identified Mr. Jack Flater,
A U.S. citizen based in Hong Kong,
as the ultimate controller, the mastermind of the whole operation. We are talking about a scheme that completely wiped out the life savings of thousands of Australians.
So to frame that as anything other than a monumental failure of investor protection, it takes some serious mental gymnastics.
It really does. And if we look at what Parliament was actually saying at the time, we see exactly why Savundra's statement is so hard to swallow.
Because Parliament demanded urgent, aggressive action. Action that it seems ASIC just didn't deliver.
And we have to look at the specific documents here. The recommendations coming out of the Parliamentary Joint Commission, the PJC, after the Trio collapse, they weren't just, vague suggestions.
No, not at all. They were urgent, powerful demands that were aimed squarely at the regulatory failings they saw.
Let's get into Recommendation 10 from the PJC, because the specificity here is extraordinary. The committee didn't just ask ASIC to, cooperate. It recommended that ASIC provide all necessary funding.
All of it. To the receiver PPD advisory, so they could pursue their investigation to a full and proper conclusion.
And this wasn't just pocket money for paperwork.
Not at all. Crucially, the committee demanded that this funding be used for conducting formal examinations on oath
of key figures, specifically naming people like Mr. Jack Flater, and they said this was needed as a matter of urgency.
This is such a critical point. An examination on oath, that's a serious legal tool.
It's how you compel testimony under penalty of perjury. It's what you do when you really want to get answers and stop people from hiding overseas.
Precisely. The PJC knew that without that specific legal pressure, the trail of money and accountability would just go cold at the Australian border.
And the mastermind would be safe in Hong Kong.
Exactly. So the failure to fund or pursue that examination meant the Australian regulator basically just let the architect of a billion-dollar fraud go completely untouched, untested by Australian law.
So on one side, you have Parliament shouting, you must urgently use your legal teeth to go after the mastermind.
And on the other, years later, you have ASIC's General Counsel claiming the feedback on their engagement was largely positive.
The two just don't line up. They're fundamentally irreconcilable.
And then there's Recommendation 11, which only highlights how unhappy the PJC really was.
Right. They recommended that the Australian Federal Police, working with ASIC, by the way, pursue criminal investigations.
And not just investigations, but where applicable, criminal sanctions against the key figures. Again, this was a matter of high priority.
So criminal sanctions against the mastermind, that's what Parliament is demanding. Yet, years down the track, ASIC is framing its lack of full compliance as proof of a positive relationship.
It begs the question, how can you ignore such a specific demand for criminal prosecution and still claim success?
Because, as the source material shows, they control the story by controlling the evidence.
This is where we hit the transparency issue. The sources lay out a fundamental structural problem that makes it almost impossible for anyone on the outside, even Parliament, to judge what's really going on.
Savandra's statement has never been fully tested. Why? Because the Senate has, and I quote, no idea as to the quantity of evidence and information ASIC has withheld from it.
It's the ultimate accountability loophole. If you're the regulator being reviewed, but you're also the gatekeeper of all the evidence.
The review becomes a formality. If the Senate doesn't even know what it hasn't seen, emails, internal reports, meeting notes, how can it possibly audit the outcome?
That's the core of the crisis. Without that vital evidence that's been denied, very few people can actually vouch for whether the regulator's version of events is accurate. They become the sole arbiter of their own success, protected by this information blockade.
And the sources are pretty blunt that this control over the evidence was masking a devastating internal failure on the TRIO case itself.
The available evidence points to a solid indication that there was, and this is a direct quote, no proper forensic investigation by ASIC of the fraudulent TRIO capital scheme.
Let's just pause on that phrase. No proper forensic investigation.
In a billion-dollar fraud case that spans multiple countries and involves shell companies, a forensic investigation isn't just nice to have, it's everything.
It's the bedrock. You follow the money, you identify the assets, you build a case that can actually stand up in court.
So if that forensic foundation was never properly laid by ASIC, it explains exactly why those urgent PJC recommendations for criminal sanctions just vanished into thin air. They didn't have the proof because it looks like they never did the work to get it.
And when you put that lack of investigation next to the lack of transparency, the picture that emerges it's really damning.
Yeah. The critique suggests ASIC is essentially congratulating itself on how it handled trios, simply because there's so little transparency, no one can actually check its work.
The implication is that ASIC just fulfill its own agenda.
An agenda of, institutional survival and controlling the narrative.
Yeah.
And in doing that became, quote, devoid of care and has no concern for victims of financial crimes. The priority shifted from protecting people to just managing PR.
Here's where it gets really interesting. Because now we move from the high-level parliamentary reports down to the crushing human cost of all this.
Mm-hmm.
We turn to Mrs. Barnett of SRG Advisory. She lobbies for victims of financial crimes, and her testimony to the Senate was just compelling.
Her testimony cuts right through all the institutional jargon and defenses. Mm-hmm. It shows you the real-world consequences of a system like this.
The only avenue for redress available in this country for a variety of my clients is through the Department of Finance under Senator, I think she's Senator Gallagher.
Yeah.
And unfortunately, the Department of Finance defers to ASIC to be judge, jury, witness. It can't monitor itself. Have you done anything wrong, Mr. ASIC? Well, no, I haven't. There's lots of examples how I have got it wrong, but I say no, so it must be right. 4 of my clients, my client groups, have lost, mum and dad investors have lost $1.5 billion. I represent 20. So you do the math. Prime Trust, City Pacific, the list goes on and on and on. The existence of Ponzi schemes in Australia is damning. It should make ASIC sit up and say, what is wrong with us, with what we are doing as the regulator, that these Ponzi schemes can happen in the hundreds of millions of dollars.
She explained how SRG Advisory applied to the Department of Finance for 3 different victim groups. They were seeking something called active grace payments.
And for anyone who doesn't know, an active grace payment is basically the government's last resort for fairness.
Right. It's compensation you get when you've suffered a loss because of, say, defective administration by a government agency, and there's no other way to get recourse.
It is essentially the government admitting its own system failed you.
And SRG's argument every single time was that ASIC's performance had been absolutely derelict, that ASIC's failure directly caused the victims' losses, making this special payment necessary.
And that sets the stage for her most powerful critique. Mrs. Barnett points out this inherent, just astonishing conflict of interest in how these claims are handled.
She says ASIC acts as judge, jury, and witness in deciding them.
It's completely circular logic. The very agency you're accusing of negligence is the one asked to decide if it was, in fact, negligent.
And whether you deserve compensation because of it.
Exactly. The source material quotes her perfectly. It can't monitor itself. Have you done anything wrong, Mr. ASIC? Well, no, I haven't, so it must be right. That scenario makes an impartial assessment impossible.
It sounds almost medieval in its lack of proper oversight. If ASIC is the one accused of causing the harm, and they're also the ones advising on compensation, the system feels rigged from the start.
Mrs. Barnett called it a medieval archaic form. She argued this structure allows ASIC to decide, answer, and, in many cases, distort facts.
So it prevents the Department of Finance from being a real, impartial judge.
And it deprives her clients of any real shot at justice. They get denied twice. First by the regulator that failed to protect them, and then by the compensation system that asks the regulator to judge itself.
And let's not forget the scale of this again. The fraud was, as the sources say, in excess of $1 billion.
This isn't just one mistake. This is a catastrophic, financially ruinous event for thousands of Australians, many of them retirees who lost everything.
The sheer amount of money lost, the fact Parliament was demanding criminal action, and that victims are left pleading for these act of grace payments.
It all points to a system that just broke down at every single point.
Mrs. Barnett's testimony really questions the entire purpose of the regulator. She asks, if the public can have no reliance on ASIC to stop these criminals, then who is going to stop them?
And this brings us right back to ASIC's own charter, the legal reason it exists.
Right. Its job is to maintain, facilitate, and improve the performance of the financial system, and to promote confident and informed participation by investors.
Every single failure we've talked about today, the ignored PJC recommendations, the missing forensic work, the self-judging compensation claims, it all stands in stark, painful contrast to those goals.
The conclusion Mrs. Barnett came to is the ultimate condemnation. She wasn't mincing words.
No, she wasn't.
She says that ASIC simply fails, that it is inept, it is neglectful, and when it comes to victims, it's absolutely devoid of care or concern.
And her final assessment.
That based on its performance, ASIC is not fit for purpose.
And that devastating judgment really captures the contradiction we started with. The regulator claims it gets positive feedback, but the people who actually lived through the failure, they see a body that's fundamentally broken, one that puts its own institutional defense ahead of its duty to protect.
So what does this all mean? We've walked through this narrative driven by contradiction. You have ASIC's claims of positive feedback,
clashing directly with urgent, unfulfilled parliamentary demands for criminal investigations into a billion-dollar fraud.
A systemic failure that seems to be protected by a deliberate lack of transparency, with ASIC withholding the very evidence needed to judge it.
And finally, the victims themselves, who are trapped in a compensation system where ASIC acts as judge, jury, and witness of its own failures.
The sources say that the victims of the trio crime can list pages of details that illustrate ASIC's omissions and obfuscations.
Which suggests there's this deep internal knowledge of all the specific failures that oversight bodies are just intentionally denied access to.
It really exposes a fundamental weakness in our governance.
It does. We started by asking how ASIC reconciles its self-praise with all the condemnation. And the answer seems to be by controlling the evidence that would prove the combination is right. So here's a final thought for you to explore further. If a powerful financial regulator controls the vital evidence needed for its own parliamentary review, and it also controls the compensation process for its victims, what kind of structural external mechanism, something outside of Parliament, is truly needed to ensure genuine, impartial scrutiny? There has to be a way to verify the claims beyond the regulator's own report card.
That is the essential question we have to answer for future accountability. Thank you for joining us for this deep dive into regulatory failure and the ongoing fight for transparency.